Welcome to Criminal Law Unfiltered.
Welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group and a seasoned criminal defense attorney who spent more than 40 years defending clients across Southern California. With thousands of cases behind him, he's known for aggressive and strategic defense in serious state and federal cases. I'm John Lieberman, and today we're breaking down the federal sentencing guidelines, how they work, who sets them, why the outcome can be so forgiving. This is episode 4, Federal Sentencing Guidelines Explained, how they work, and what impacts your sentence. And Robert, let's start with the basics. What are federal sentencing guidelines and who created them? What's the impetus for them?
Well, first of all, I want to say nice to see you again, Johnny. It's
nice
been a while.
to see you too, Robert. I was hopping right in because I know you have a lot to say on this topic.
Well, one thing I wanted to make clear about federal, you had said that I've handled serious state cases and federal cases. My federal experience is not limited to Southern California. I do federal cases across the country. So I can compare different jurisdictions and the way that cases are handled. The federal guidelines were established by Congress, and so there's the short version of this is that there's a committee that decided for this type of crime, this is what we think should be the recommended sentence on that. Years ago, the guidelines actually came into effect. I believe it was in the 80s. And it was a way so that you could make sentences more uniform across the country. So in other words, without the guidelines, you really didn't know what you were going to get because you had a judge, and that judge could do whatever he or she kind of felt was appropriate under the situations, given somebody's background and the severity of the crime. Now there's federal guidelines, and then I would say about 20 years ago or so, the guidelines became recommended. They weren't mandatory. So what happens is that when you figure a guideline sentence, the judge, that's their starting point. That's a judge goes, okay, this is the guidelines. So when you have a federal sentencing, the first half of it is figuring out the guideline sentence. The judge figures out, well, there's your base offense level. You get a few increases for this. You get a decrease because you accepted responsibility. You're a 0-point offender we have now. So there's different things that give you a downward departure. And then a judge can determine what your guideline range is. And all of that is also subject to debate with the court. I mean, you can object if you think your guidelines, this guideline provision doesn't apply. And because what happens was a guideline comes into effect either once when either your client was found guilty by a jury, then you're set for sentencing. So then, or you you have a plea agreement, and then the guidelines come into effect. So what happens after either one of them, those events, either a guilty verdict or a plea, probation, United States probation officer interviews you. Of course, it's important for your counsel to be at that interview to limit what they're going to ask. Mm-hmm. There are certain things I don't want to be put in that report. And that report is quite extensive. They ask you all about, where you were born, what, you're all about your siblings, talk about mental health. They talk about substance abuse. Substance abuse is key in many cases because it's a way that you can reduce the amount of time you're exposed to if you're going to go to the Bureau of Prisons, if you're going to go to prison. So it's important to know the ins and outs of the guidelines. But also, if you're actually entering into a plea agreement with a federal prosecutor, one of the other aspects of that is you need to know and try to avoid a mandatory minimum. So there's the federal law, which is ridiculous. You'll read that the maximum sentence on a certain federal crime is 25 years with $1 million fine. Well, that doesn't apply. That's just the maximum sentence that you could actually end up getting, which never happens because the judge uses the guidelines to figure out an appropriate sentence. However, the reason I bring that up is because there are many crimes that have mandatory minimums, like drug crimes. There are drug crimes that have 10-year mandatory minimums or 5-year mandatory minimums. There are crimes to do with identity theft that carry 2-year mandatory minimums. There are crimes that have to do with child pornography, and where, if a prosecutor charges you with receipt versus possession, receipt has a 5-year man-min, and possession has no mandatory minimum. If you produce child pornography, if you manufacture child pornography, if you coax a minor to come over state lines to meet you, these types of crimes have mandatory minimums. The reason I bring that up is if you need to try and negotiate out of a mandatory minimum with the prosecutor, because sometimes in some of the cases I've just told you about, your guideline range would be less than the mandatory minimum. So that you need to not fall into the trap of pleading to a mandatory minimum. So that's what you need to look out for, is to try to avoid the man-mins, the mandatory minimums, and you need somebody that knows how to work with the guidelines.
Yeah, that's super interesting because I think people hear mandatory minimums and they say, I'm going to get this number no matter what. But the reality is there's negotiation on every front if you have a skilled negotiator on your side.
Well, there are ways for sure to get under a mandatory minimum. Like in drug cases where you see a lot of these man-mins. If you have you have a minimal criminal history, and when I say minimal, I'm saying some misdemeanor offenses which don't involve violence, then you would be qualified for what's called safety valve. And that will allow you to get under a mandatory minimum in a drug case. Of course, I'm just going to talk about this topic briefly because it's very touchy. If you're so inclined and you want to speak with the government, that's called a 5K1. What a 5K1 means is cooperating with the government. And I'm going to tell you right now, every single federal case, the government comes at you and wants to know if your client wants to cooperate. This government that we have is very interested in information. They want information. And it's valuable to them. And so they really encourage you to at least ask your client. They encourage the client to come in and have what's called a proffer session with them so that they can, and that's a way, because what happens is at the time of sentencing, the government files what's called a 5K1 motion. It's a downward departure motion at the time of sentencing, which can get you under a mandatory minimum and actually get you a downward departure on the guidelines, so your score is not so high. So I'm finding I don't my job is to present that option to a client, and they need to talk to me seriously about whether or not they want to do that. Many people don't want to do that. Many people just say, I'm not going to. I am not going to. Some people, it's a ethical thing to them. They don't want to so-called rat out somebody else. I got myself into it. I'll take the blame. Other people say, I'm not going to subject my family to the danger of me, giving information on somebody else. So I don't want to do that. And another thing is, when people say that to me, that I'm afraid that if I say something that, my family or I'm going to be in jeopardy, the threat of harm, or it's real. It is real. And everybody has to judge that for themselves. And I don't find that the government is so, ready and willing and able to defend you. Okay, because they could say all they want, but they're not out in the street, So there is a certain aspect of cooperating. I believe that, the government, that they're going to do you a favor. They're going to take your information. They're going to do their investigation. But, if you're going to do that, you need to, if you want to cooperate, you need to question the U.S. attorney and the law enforcement agency very carefully to find out what it is that you will do to protect me and my family after I walk out of here, and not throw me away like a piece of trash, which I've seen.
Robert, can those 5K1s be sealed so that nobody knows that a defendant cooperated?
Well, that's a good question, John. That's what happens, is those things are sealed on the record. So, your docket on your particular case is public record. And if you end up going to prison, the inmates are very interested in your docket. And even though your particular pleading, so to speak, is sealed, it's suspicious. And don't think that, like an experienced inmate who looks at the docket and sees, a request to file under seal, which is what you need to do, is you have to ask the court for permission to be able to file something under seal. And when an inmate looks at that, they're going to question you. And they want you, if you're going to prison, to bring your probation report so they could see, what you pled to, what your guideline range is. And so if you've got a guideline range of 15 years, you ended up with 6, they're going to look at you funny. And these are things you need to think about. And these are things that more and more and more people say, I don't care. I'm not going to cooperate. I'm just not. I'm not going to risk my personal harm to save myself 5 years.
And Robert, last question. Who decides if the information that the client has proffered is valuable information, valuable enough to warrant a deviation from the sentencing?
The government. And when you decide, or if you decide it's in your best interest to do it, and you decide that you're not in danger, and you will get you'll get a proffer agreement. It's like a 2-page letter. We call it a queen for a day letter. And what it is it says that we're not going to use anything you say against you, but we might use what you say against somebody else. So if you lie, we could use that against you. But what is very important in there is that you're not given any promises. You're not given any promises whether or not the information you give is going to be helpful. And you're not given a promise as to if it's helpful about what we're going to do for you, what the government is going to do for you. It's all within their discretion. Now, when I've had cases where I felt where they have accepted the cooperation, they did get a 5K1, and the government at the time of sentencing said, okay, I think 5 levels down is appropriate in this case. The defense attorney or myself, I'm free to argue, Your Honor, my client ratted out the president of the United States, and we took the president of the United States down. So, and that's not, I'm not saying, my client, this is what my client did. And without my client, they would not have gotten Mr. X or Mrs. X. And so five levels down is not enough for what my client did. And I've had many times where the judge agreed and said, you're right. So it is up to the government to, one, accept what you gave them as truly cooperation. It has to, there is a definition to it. You have to substantially assist them in the investigation, either in that investigation or another one. I haven't really been seeing that. I've never really had a client burned that way where they weren't given the 5K. You could kind of tell that they've done well. The only issue really comes in is whether or not you feel that your client was compensated fairly and reasonably for what they gave the government. And that's where it comes. So it's a sentencing issue. So there's a lot we could talk about, federal sentencing guidelines for, we could take up about 6 or 7 episodes if you like, but there's a lot to it.
We could do a whole law school tutorial. Well, Robert, thank you so much for your time, and thank you all for listening to Criminal Law Unfiltered. If you or someone you love is facing a federal indictment, you just heard Robert operates in every state there is when it comes to federal charges. The sentencing process, as you heard, can feel like a trap, but with the right legal strategies, there are often ways to fight back, and you can visit robertmhelfend.com to learn more. And of course, be sure to like, subscribe, and share this episode with someone who might find it valuable. Thank you so much.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.